Welcome everybody. Thanks for joining the call this morning. Webinar that we're going to present is, as you can see, on employment tribunals and taking you through the current hot topics that are in front of the tribunal. My name is Paul Duffy. As you can see, I'm a senior manager here at LHH Recruitment Solutions. We're the professional recruitment arm of the LHH business. My own particular specialism is in the legal sector. And within that sector, we get to partner with many of the UK's leading law firms. As a result of that, I'm delighted to say we're joined by a subject matter expert, Phil Crowe, who's a partner in employment law at Shoesmiths. Obviously, the employment tribunal and the decisions that is reached by the employment tribunal has a huge impact on the day-to-day running of HR teams. And so we thought this was particularly pertinent for you guys to have the opportunity to hear from Phil in relation to 3 or 4 of the real recent hot topics that is in front of the tribunal at the moment. And as I said, the impact and ramifications that will have for you in your role and your businesses. A few housekeeping questions. When we ran this seminar yesterday in person, we felt that it worked better with people asking questions as we went along rather than to the very end, as it meant that it was sort of in real time and Phil was able to respond to stuff that he was talking about. So you have a couple of options with that. There is a Q&A section within Zoom calls that you can use, or as I can see people already are doing, you can use the chat. So I'll be monitoring that, and as the questions come through, I'll alert Phil and he can cover them off. Just so you're aware, I think you can see we are recording this webinar. And I think it will be sent out via Graham and the LHH team at the end. So without further ado, Phil, I'll hand over to you.
Yeah. So as Paul said, my name's Phil Crowe. I'm a partner in the National Employment team here at Shoesmiths. Just a little bit about me and us, and I promise you this isn't a sales pitch. It'll be very brief. So Shoesmiths is the top 50 national commercial law firm. We have 13 offices across the UK, in England, Scotland, and Northern Ireland. As an employment team, we're one of the largest in the country. At last count, which I did this morning, we've got just over 70 solicitors in our team, and it's, as I say, one of the largest employment teams in the country. We specialise in all aspects of employment law and people, essentially. I myself, I've been around for a number of years, many more years than one cares to remember, but there's probably nothing I haven't done or seen or come across when I've been advocating in the employment tribunal. So I've seen all the weird and wonderful things that rear its head in the tribunal system. So by all means, if you have any questions about that or any questions about the topics we're going to discuss, as Paul says, by all means, ask as we go along. I'm happy to pick up any questions. Before we delve into the what's hot, I thought it was helpful, or it might be of interest to people to put into context where we are with the employment tribunal system at the moment. So last financial year ended April 23, there were 100,000 new claims in or coming into the employment tribunal system. Of those claims, 36%, so 36,000 essentially, claims were what we call single action claims, which basically means they were a claim brought under one law, essentially. So a claim for unfair dismissal, a claim for unpaid wages, a claim for breach of contract. They were single action, relatively straightforward claims. The remaining 64%, 64,000 claims, were what we call multi-action claims. So basically they were involving one or more, or two or more rather, types of legal complaints. So your unfair dismissal and discrimination, your unfair dismissal and whistleblowing, your discrimination and whistleblowing, your discrimination under different heads of discrimination. So what we can see from that is not only are there a lot of claims coming into the employment tribunal system, but those claims which are now coming into the employment tribunal system are a lot more complicated, sophisticated, for want of a better phrase, than have normally been the case. Individuals understand that they can bring more and more complicated, detailed, and potentially lucrative claims for them if they are successful. So one overarching trend is claims are getting more expensive, claims are getting more complicated, claims are getting more time consuming. And I don't see that stopping anytime soon either. So again, just to complete the picture, there are currently 500,000 claims sat in and/or passing through the employment tribunal system. So I was asked the complicated or difficult question as to what is hot out of those 500,000 claims. And it's interesting because obviously claims and what claims are brought are dictated in the main by the claimants, by the employees, ex-employees who are bringing those claims. It's not the judiciary that sets the agenda. It's not government that sets the agenda. It's not us as lawyers who set the agenda, or you guys as employers. It's the claimants. It's the individuals who do that. That said, and many of you will be well aware of this, there are some headline types of claim which are passing through that system. Of the last 5 years, I think the biggest, most high-profile type of claim was the gig economy claims, was the worker status claims, was the employee status claims. Most of you, I suspect, will have seen on the BBC and or any other news forum the claims involving Uber drivers, the claims involving Deliveroo riders, claims involving the Pimlico plumbers claims, which were all about the gig economy and establishing workers' rights for those non-traditional types of worker. I myself am currently dealing with a 700 claimant worker status issue. So that has been the headline grabber type of claim and still will be, I think, for a number of years to come. But don't worry, I know it's quite niche and it's quite technical. We're not going to look at worker status today. That's had plenty of press. We're going to look at some other things which are possibly not as press generating, but trending all the same. So what are we going to look at? So first and foremost, we're going to look at holiday entitlement and holiday pay. Again, many of you people practitioners will know over the last, again, possibly 5 to 10 years, holiday and holiday pay has been an area which case law has changed. Potentially every time a case gets to the upper courts, they vary how we deal with calculating holiday entitlement and holiday pay. And we've had a recent judgment, which again has had an impact on that. So we're going to look at that. We're also going to look at some discrimination claims. And 2010 was when the Equality Act was brought in, so 13 years ago. And society, people's views, a lot's changed in those 13 years. And when that legislation was written, obviously they had the 9 protected characteristics. I'm not going to ask you guys to put in the chat what those 9 protected characteristics are. We're not going to do any quizzes today. But obviously those protected characteristics are of their time, and people view their rights, they require their protections in a slightly different way 13 years later. So we're going to look at how the Equality Act is being molded and shaped to fit the modern world, essentially. And one of those particular areas is menopause, and how we're going to look at how the Equality Act is being used in its current form to assist and provide protections or create risk, depending on which side of the fence you sit at, for employers. So, without further ado, we are going to look at holiday. And I say holiday because I am going to talk about holiday, both holiday entitlement calculations and holiday pay issues. And for those of you who are people practitioners, I don't need to tell you how complicated the law and the judiciary in the main is making calculating holiday entitlements and calculating holiday pay. So just to again set the scene, as you will all know, in the UK, all employees or workers are entitled to 5.6 weeks paid annual leave. That annual leave is made up of two distinct entitlements. The first 4 weeks of the annual leave is derived from the Working Time Directive, so European legislation, and what we imaginatively call Euro leave. And the next and additional 1.6 weeks is derived under UK law, under the Working Time regulations, and that, again, imagination from lawyers, we call additional leave. So there's two elements which make up that 5.6 weeks leave. The reason why that's important is because how the case law has evolved dictates that we pay or can pay workers differently depending on which period of leave they are taking. So for the Euro leave element, workers are entitled to their normal remuneration, which is basic pay plus guaranteed bonuses plus commission plus guaranteed and regular overtime. That all gets added together to form their normal remuneration, and that's the pay they're entitled to for their 4 weeks Euro leave. In terms of the additional leave, under the Working Time regulations, workers are only entitled to their basic pay. So it's important that we understand the distinction between the two. And for a while, the case law and the legislation was settled, and we knew that we had 4 weeks Euro leave. We knew we had 1.6 weeks additional leave, when we knew the two different pay structures according to the period of leave. We also knew, and this wasn't written down anywhere, but it was taken as custom and practice, we also knew that tribunals considered the first 4 weeks of someone's leave would be taken as the Euro leave, and then any additional leave on top of that would be taken as their additional leave. So it was clear which period was which and which pay requirement fell into which buckets, essentially. We also knew that when bringing holiday pay claims, there was what we lawyers call a causation break issue. So if there has been a period of 3 months or more between breaches, essentially, of the holiday rights, those breaches couldn't be linked together, which made claims relatively finite and relatively discrete, and often not worth bringing for claimants, because most of the substantial elements of their claim was potentially out of time. We also knew that there was a 2-year backstop on how far back, even if those claims could be linked, employees and workers could take their claims. To say we knew, because last month, rather unhelpfully, the Supreme Court passed down its judgment in the Agnew case. And this case had been rumbling on for a number of years, and it had progressed from the Employment Tribunal to the Employment Appeals Tribunal to the Court of Appeal, and eventually made its way to the Supreme Court. The overarching challenge which was being raised by the claimants on this particular claim was they didn't believe that there should be a 3-month break in causation, and they didn't believe that the leave period, the 5.6 weeks, should be divided up into those two distinct pots. And again, for you people practitioners, I'm sure when this judgment came down, your inboxes would have lit up because employment lawyers across the country were sending updates out about this, because it made quite a significant change. And what that change was that the Supreme Court found that the breaking causation didn't necessarily work. Essentially, what they said was that if claims or periods of leave or periods of entitlement to claim were more than 3 months apart, it didn't necessarily restrict them being linked together if they could be found to have derived under a common mistake, is what they've said. They don't go on to say what common mistake is or what common mistake even means. But taking a plain English reading of that, common mistake is likely to mean it's the same employer, same contract under which the worker is working that gives rise to the breach. So for all intents and purposes, that 3-month chain break no longer exists unless people are moving on to different periods of employment. If it's the same employer, same employee, same worker, then we can no longer rely on that to essentially get us out of going all the way back potentially to the start of their engagement in relation to holiday pay, subject to potentially the 2-year. What they also went on to say is that the 5.6 weeks leave is a composite pot. It's not distinguishable by 4 weeks Euro leave, 1.6 weeks additional leave. It's all mixed together, essentially, which for those of you having to calculate holiday pay creates an absolute nightmare, for one of the better technical phrase, as if you are paying workers differently for Euro leave because they're entitled to normal remuneration and you're only paying basic pay for additional leave, we now no longer, according to the Supreme Court, can distinguish which period of leave is which, and therefore what do we pay for that particular worker's pay when on annual leave. Unless, and this is how the Supreme Court have tried to caveat that confusion, unless it's not practicable to distinguish the two, that's when it becomes a composite pot. If it is able to be distinguished, then you can still identify which is Euro leave and which is additional leave and pay accordingly. They've given no guidance as to how to make it practicable. However, the sensible thing to do is to have in your employment contracts, and many employers do this already, but if you don't, the sensible thing to do is to have in your contracts and in your holiday policies details of which part of the worker's leave is essentially which. So it's as simple as having in your employment contracts, the first 4 weeks of your annual leave entitlement is, and call it what you will, it's semantics, but is leave derived from the Working Time Directive, or is Regulation 13A under the Working Time Regulations leave, or is Euro leave? It doesn't really matter what label you put on it, but as long as that distinction is made, you should be okay. And then obviously the next part of the paragraph needs to read that the next 1.6 weeks is going to be regarded as additional leave under the Working Time Regulations. So why is this problematic? Well, I think it's self-explanatory as to why it's problematic. It causes a great deal of confusion. But why does this make it hot for the purposes of a presentation dealing with the employment tribunal system? Well, with confusion comes opportunity, essentially, for claimants to raise challenge. And not only that, the removal of the 3-month limitation essentially makes these claims much more lucrative, both for claimants and also for lawyers and trade unions to push those claims, particularly for those law firms who take a cut of compensation. In the past, if you were running a claim which was worth a couple of £100, it's not really worth it. Now, if we're getting into potential tens of thousands of pounds, it's worth it for those lawyers to start pushing those claims. And also with the confusion as to what is payable in which pots, again, it provides opportunity to challenge. So I am expecting to see a big spike in unlawful deductions from wages and holiday pay claims on the back of this decision in Agnew. Before we move on, is there any questions on that topic, Paul?
Not on that, Phil, but the questions come in about hybrid and flexible working policies and the impact on claims around that. And I know that you sort of touch upon that later in the presentation, so we will get round to that, but it comes up a little bit later on. So far, just that one in.
So the next limb of holiday pay that I want to talk about is the concept of rolled up holiday pay. So again, just to put this into...
Bill, sorry, can we go back? So a question has come in just to ask, is the 3 months that you refer to in regards to how long, so the limitation point on the claim, I don't think it is it?
No, it's both. So in theory, you have 3 months from a breach, so either a fail to grant leave or fail to pay properly, to bring a claim. However, it's the last of the series in which you can bring the claim. So it used to be that if there was 3 months gap between the series of deductions, it broke the chain, and you couldn't rely on the deductions going all the way back to potentially the start of the engagement. What the case law now says is that if you bring a claim within 3 months of the last of the series of deductions, regardless of whether there's a 3-month break within that series, within that chain, you could potentially link them all together.
Okay, thanks.
So going back to rolled up holiday. So a number of years ago, back to the early 2000s, it used to be permissible to have workers, employees take unpaid leave, provided when they were at work, they received an additional 12.07% pay. That essentially was rolling up their holiday pay entitlement into their normal pay, which meant that when they were on annual leave, you didn't necessarily have to pay them. Hence, again, you'll see from many of the labels that employment lawyers put on things, it's not particularly imaginative. Because that pay was rolled up, we called it rolled up holiday. In 2006, the European Court of Justice intervened and said, no, this isn't right. You can't do this. You have to pay workers, employees for their holiday when they're actually taking their holiday. So the concept of rolled up holiday pay was essentially made unlawful in the UK. To deal with this concept, and we're particularly talking about irregular hours workers or part-year workers, really, in this context. To deal with this issue, it was decided, or many employers introduced the concept of giving employees, workers, 12.07% of their working hours as leave for their leave entitlement. And I should say that the 12.07% isn't just an arbitrary number that's been invented. Essentially, and I'm no mathematician, so I've had to write this down to get the details exactly right. 5.6 weeks annual leave entitlement, 46.4 weeks working weeks in a year. 5.6 weeks is 12.07% of 46.4 weeks. So that's where the concept of the 12.07 comes in. And this was fine. This was all established law. Everyone was, whether they were happy with it or not is a separate question, but everyone was content that they understood the position. Until the Supreme Court again intervened, and in the case of Harper Trust and Brazil, basically said that that concept was unlawful, and said that part-year workers, irregular hours workers, were still entitled to a full 5.6 weeks paid annual leave, and it made the concept of the calculations by 12.07% unlawful.
Bill, sorry, we've had a question come in. You've obviously your maths has excited people. Can you just explain how that 12.07% was calculated again?
Of course. So workers are entitled to 5.6 weeks annual leave. There are 46.4 working weeks in a year. So 5.6 is 12.07% of 46.4. Essentially, that's where that number comes from. Anyway, so the Supreme Court said that was unlawful, and part-year workers, irregular hours workers, were still entitled to 5.6 weeks paid annual leave. This caused a huge problem, huge furore, particularly for part-year workers, and particularly in the concept of an exam invigilator, who I find it really difficult to say invigilator, so I may have got that word wrong. But in this context, the exam invigilator, the worker, essentially worked 1 week a year. But what the Supreme Court found was that, in spite of the fact that she only worked 1 week a year, she was entitled to 5.6 weeks paid leave. So essentially, she was entitled to more paid leave than she actually worked, which I'm sure everyone on this call will agree is a I can see a shocked face coming up on my screen. So I didn't know that they could do that. So I assume that means that everyone agrees that that is an absolute bonkers position. So unsurprisingly rather, surprising and unsurprising in equal measure, business was outraged at this decision, and so were many full-time employees, because their colleagues who work part-year or irregular hours were having such a better holiday benefit and entitlement. So a lot of lobbying went on to government, and they listened, and they have introduced some legislation to fix the problem created by the Supreme Court. And what they've done is they have reintroduced the concept of rolled up holiday pay. So that, having been unlawful since 2006, is now permissible, or will now be permissible again, provided, and these are the only caveats, but provided it's only applied to irregular hours or part-year workers, provided the 12.07% calculation is used and not a lesser number, provided that 12.07% additional pay is paid essentially in the normal pay run when the workers are working, and provided there's an itemization of that receipt of pay on their pay slips. What they've also reintroduced is the concept of the 12.07% calculation to determine holiday entitlement. So it's not the 5.6 working weeks for someone who works 1 week anymore. It's 12.07% of that 1 week that they're now entitled to as paid annual leave. And the legislation introducing this comes into force in January 24 and will apply to all holiday pay and leave taken in the holiday years commencing April 24. So the reason why this is important is, well, it's a good news story, so I thought everyone would like to hear it. It's actually some really helpful legislation for business. But also, we have a legal phrase, we call it a lacuna. It's Latin, it means gap or hole, essentially. So we now have a gap between now and the law being bonkers and January and or April next year of when the law is corrected. So what that theoretically means, even though the correction is coming, employees, workers do have the ability to claim under the broken law as is at the moment. So those part-year workers, those irregular hour workers, unless they're getting this super entitlement that they're entitled to at the moment, may well think they want to cash in and bring an employment tribunal claim quickly now before the law changes and they lose the entitlement to which they've just been granted by the Supreme Court. So I expect a bit of litigation to pass through the system in relation to that.
Bill, quick question. Laura Cross would like to know, is this paid at a normal base salary hourly rate, or is overtime to be included?
It depends which pot of leave it is. So the same rules will apply. So it would be 12.7% of normal remuneration if it's Euro leave holiday, or it would be 12.07% of basic pay if it's additional leave holiday. So it's still those pot rules still apply.
But the Euro leave would include the overtime, yeah?
Yeah.
Yeah, okay.
Guaranteed overtime would fall part of normal remuneration, so that would still fall into that, yes.
Okay, thanks.
Oh. Okay, so we're going to look at some discrimination cases now, and as I said, the reason discrimination has been around since I think it was the Race Relations Act 1976. I think was the first piece of discrimination. I may be wrong, so if someone knows better than I, by all means feel free to correct me in the chat box. But from memory, I believe that was the first piece of discrimination legislation which was introduced into the UK. So the concept of discrimination isn't necessarily new. Well, it isn't new, and nor is it necessarily hot as a topic passing through the employment tribunal system, because ever was it thus. We've always had discrimination claims passing through the system. Why I wanted to talk about this today is because of the nuance being placed on discrimination claims in our different world. As I say, it was 2010 when all discrimination legislation was brought together under the One Equality Act, but things have evolved since then. People's society's views, opinions as to what is, quotes, discrimination has changed. And the Equality Act is having to work harder and differently to keep up with that change of societal norms, essentially. One reason discrimination claims, or a number of reasons why discrimination claims are still here and will never go away, is the value of them. So these are very favourable types of litigation for claimants to bring, because as we all know, there's no cap to the compensation that someone can achieve through a discrimination case. It can be reputationally quite damaging if even if the employer wins, and this has happened to me a number of times in my career. I've been in tribunal defending a business, and essentially, for want of a technical phrase, they've done nothing wrong, but they've had discrimination claims brought against them by unreasonable claimants for the most part. The claims and the complaints always find their way into the press. They'll always report the claims and the complaints. They don't stick around to find out what the judgment is, and they don't find out or stick around to find out that actually the employer has been exonerated of all the allegations made against them. It's just the claims which tend to find their way into the public domain, which is massively unfair. But unfortunately, that's the world in which we live. So they are both lucrative for claimants and also quite powerful if you have an unscrupulous claimant who basically just wants to force through a settlement or take some revenge on a business or an individual, because as we all know, discrimination claims can be brought against individuals as well as business. So one really interesting discrimination case I wanted to talk about is it's a philosophical belief case, and these have always been difficult cases. As I say, race, religion, and belief protection has been around for a long time, and we all understand religion, belief protections. We all understand what a religious belief is, and we, for the most part, all know what is and what isn't protected under that head. Philosophical belief, however, is slightly different. It's slightly more complicated, because what is essentially a philosophical belief? And again, helpfully, or not, as things tend to be in legislation, it's not defined. We don't have a statutory definition as to what a philosophical belief is. We do have case law, which has assisted and provided guidance as to what the beliefs a belief needs to be to amount to a protected philosophical belief. And that is, the belief must be, there's five categories it must tick. It must be a genuinely held belief. So it has to be a passionately held belief and genuinely passionately held. It can't just be someone's opinion or view. It has to be a weighty, substantial belief in the concept of human life and behavior. Again, it can't be just a, and I mean this in the most respectful way possible, but it can't be just a silly belief that someone has. It has to be weighty, it has to be substantial in the concept of wider human behaviors. It has to have a certain level of cogency, seriousness, cohesion, and importance. And this is the really important one, and this is what we'll look at in the concept of this case that we're going to talk about now. It must be worthy of respect in a democratic society, not incompatible with human dignity, and not conflict with the fundamental rights of others. So there is a hurdle for people to overcome in relation to ascertaining a protected belief. It's not a particularly high bar, even though those fancy legal words I've just said, it's not a particularly difficult test to satisfy. And we'll see that in this concept. So Ms. Forstater was a fellow, self-employed fellow, working on a consultancy agreement for CGD. She held, she still does, I believe, holds strong views in relation to gender identity, such that she basically doesn't recognize transgender as a concept. She is very passionately focused only on biological gender being capable of recognition. And manifesting these views on X, formerly known as Twitter, I believe is the way to describe it, she made a number of offensive and essentially derogatory comments about trans women on Twitter, and shared some pretty offensive jokes about trans women having male genitalia, for one of a typical, particular biological phrase. And her CGD got wind of these tweets and terminated her consultancy agreement, essentially. And she complained to the Employment Tribunal to say, I hold a philosophical belief. I have expressed that philosophical belief, and I have been treated less favorably because of that philosophical belief. Case went to the Employment Tribunal, and the Employment Tribunal said, no, yes, you have a belief, but it's not a belief capable of protection, because the act of misgendering and the way in which you're doing it isn't capable of respect in a democratic society. It's not compatible with human dignity, and it impinges on rights of others. So they said, not a protected belief, no claim. Ms. Forstater didn't leave it there. She pursued her claim to the Employment Appeal Tribunal, and the Employment Appeal Tribunal agreed with her. The Employment Appeal Tribunal said, actually, yes, we agree. Your belief is capable of protection. It shouldn't be excluded from that protection. And what should only be excluded from protection are views which advocate Nazism or totalitarianism, or espouse violence and hatred in its gravest form. And I emphasize the violence and hatred in its gravest forms, because they went on to say that, essentially, I'll paraphrase, but essentially, well, she's only a little bit hatey, she's only a little bit espousing violence. And that, again, shock faces, I'm enjoying the animation. That apparently wasn't incompatible with a democratic society. It wasn't incompatible with human dignity, and it wasn't incompatible with the fundamental rights of trans people in this instance. So it was deemed to be a protected belief, and she was allowed to carry on with her claim. It was sent back to the Employment Tribunal for a second hearing. It's important to make the distinction here, though, in that the protection of the belief is one thing. The way in which someone manifests those beliefs is entirely different. So if Ms. Forstarter works with a trans person, for example, and bullies them or harasses them or is otherwise unpleasant to them because she doesn't believe in transgender rights, that wouldn't stop her employer or the engaging business on this occasion, wouldn't stop them from taking action, because that's still misconduct, that's still harassment under the discrimination legislation. The important thing is you don't deal with someone because of the belief, you deal with someone because of the way they're expressing the belief. And that's where CGD, difficult to say, went wrong on this occasion.
Bill, a couple of questions on that. Obviously, what you said was a little bit tongue-in-cheek. It's a good question that's come out of it in terms of, how HR professionals deem that behaviour. So your interpretation of that judgment as it's sort of okay to be a little bit Haiti, how is that to be judged? How do you see? It's a good question. So how do you legally define something that isn't definable, I suppose?
I mean, that's a $1 million question, in that we as lawyers interpret judgments essentially, and the specific wording of the judgment was that beliefs that are offensive, shocking, or even disturbing to others, which this clearly is, and which fall into less grave forms of hate speech shouldn't be excluded. So there's no demarcation as to what is grave and what isn't grave. There's no hard and fast, that's grave, this isn't grave. We essentially don't know is the answer.
And that would be decided on a case-by-case basis as it goes in front of the tribunal?
Indeed, it will have to be. And same for HR professionals. Well, actually, yes, for HR professionals, it's a judgment call for you guys to make. I mean, for me, I would be more than happy to stand up in the employment tribunal and defend a business that has dismissed someone for saying less grave hate speech or speaking less grave hate. That's not going to cause any kind of reputational damage. And if you're wrong, okay, you may lose the claim and you may have to pay out some compensation, but at least on a moral footing, you've probably taken the right action. But the key really is the point I was making about manifestation. It's don't action anything against the individual because of the belief they hold. Action or take action or discipline or remove whatever you feel appropriate because of the way in which they're manifesting the beliefs. So what CGD should have done on this occasion is end the contract because of a breach of the social media policy.
Right.
Things like that. Instead of, you believe this, so we're not having you. So that's the way in which you should tackle it, essentially.
Okay. I think there's a follow-up question, which I think you just answered there. How would this be managed in terms of the sliding scale of hatred, thinking specifically in terms of microaggressions?
Well, again, it's the same answer to the question. There's no definition of what is grave and what is not grave. You have to just take it at face value and in a plain English interpretation as to what is grave and what's not grave. It's a judgment call, essentially, and it's a difficult one to make.
I know we need to move on, but this has obviously generated a lot of interest, and I think this is a good question. But I think you've answered it in terms of, what if another employee raises a grievance against somebody due to those beliefs?
Well, you can deal with the grievance still, but it's not belief top trumps. So just because someone has a belief and someone doesn't like the belief doesn't necessarily entitle someone to raise a grievance about someone's belief.
Okay.
People, as the case law says, people are entitled to their own beliefs. So if for example, there was a trans person working with Miss Forstarter and they complained, I don't want to work with someone who doesn't share my beliefs. And again, I don't mean this to sound trite, but ultimately tough, because people are entitled to beliefs unless she's manifesting her belief in a discriminatory way toward that person, which is a totally separate thing. It's not for person A to dictate to person B and or the employer what type of beliefs other employees should have, unless they're manifesting it in the wrong way and they're essentially harassing, bullying, or doing other acts of misconduct because of that belief.
Yeah. And then final question on this, which again I think you sort of answered. In essence, does this principle then extend to other types of hate speech, for example, homophobic hate speech or racist speeches and beliefs?
Absolutely. I mean, this case isn't necessarily about the type of belief that Miss Forstater had. It's about belief in general and how beliefs can be protected. So exactly right. Any belief which strays into protected characteristic area, it would apply to.
Okay, there's a few more. We'll move on, and obviously, if people want to reach out to Phil at the end, then more than welcome to do so. I'll let you move on, Phil. Thanks.
The next topic I really want to look at, and we are coming up against time, so I shall be as quick as possible. Is menopause. Obviously, this is a very high profile topic in the people space at the moment. A huge amount of profile is being afforded to menopause rights and the introduction of menopause policy across loads of business. And it's probably the question we get most in relation to policies and procedure at the moment. Can you draft us a menopause policy? Can you do us some training on managing menopause in the workplace? So it's a really high profile, important topic. But there's no discrete protections for it under the Equality Act. And whilst people have, or businesses have, government have been lobbied to introduce menopause as a specific protected characteristic, much in the same way as pregnancy, it's been resisted. Government has said no, they're not going to introduce menopause as a specific protected characteristic. The existing provisions of the Equality Act still or will afford the appropriate protections for people who may have suffered less favourable or detrimental treatment in the workplace because of going through the menopause. So I'm not a doctor, and I made this very clear when I did this yesterday in person. I'm going to make it very, very clear again. This explanation and definition has been taken from the LHH website. Cards on the table, no plagiarism, but this is where it comes from. But I wanted to go through it because once we've spoken about this, I want to come back to the Equality Act and we can explore how it affords protections in respect of this definition and these symptoms, essentially. So menopause definition is where a woman's periods have stopped for 12 months or more. It affects, in the main, women between the ages of 45 and 55. It's recognised that it affects anyone with a menstrual cycle, so not necessarily women. Back to the issue in relation to trans, it can affect non-biological women who identify as biological women who identify as men. And the way in which it manifests itself, and I know it's very, very different in lots of different cases, but again, according to the NHS, my kind of get out of jail free card in relation to my doctoring knowledge: anxiety, sleep difficulties, palpitation, joint pain, migraines, low mood, skin changes, UTIs, flushes, brain fog, all relatively complex and serious conditions on their own. When put together, I suspect much worse. So what do we have in our armour as employees, or what do we need to be mindful of the risks as employers, particularly in relation to the current discrimination legislation in the Equality Act? So, again, I'm not going to go into all 9 protected characteristics. The key ones that can afford protection to people going through the menopause are age, sex, and it feels uncomfortable to say it, but disability discrimination. So let's go back to our, if I can There you go. Let's go back to our symptoms definitions. So, if it's someone whose periods have stopped for 12 months or more. Sorry, before we go on, just to I guess set the scene again. Definition of disability under Section 6 of the Equality Act is where someone has a physical or mental impairment which has a long-term adverse effect on their ability to carry out day-to-day activities. So first and foremost, let's look at this in the concept of disability. So 12 months or more, is that long-term? Tick. Yes. Is this a condition? Well, if we look at our symptoms, then it certainly has physical and or mental elements to it. So yes, it's absolutely certainly both a physical and mental condition. Does it have a substantial adverse effect on someone's ability to carry out day-to-day activities? Well, again, just looking at that list of symptoms, I would strongly advocate and advise that if those symptoms are relatively prevalent and relatively serious or severe, then absolutely the definition of disability will be satisfied. Just to set again the context, substantial adverse effects is what the law requires. However, the law also goes on to say that substantial is only more than minor or trivial. So it's not a very high bar to get to, is not substantial. Okay, so I would suspect that more often than not, someone going through menopause would probably be considered as a disabled person. Age discrimination. Well, by definition, it affects people of a certain age. So there's going to be an element of age discrimination potentially at play here, and sex discrimination as well. It affects, well, it only affects biological women. It doesn't affect men. Biological men. So there is an element of protection under the sex discrimination provisions as well. However, for my part, I think the most sensible way to run a disability discrimination claim, if I was a claimant, would be under the disability legislation. I think it fits better in that category. We are pressed for time, so I'll just run you through a case really quickly, because the point being, menopause cases are now hitting the Employment Tribunal, and they are specifically testing the Equality Act application to that. And we had two recent ones. The first one was Ms. Rooney. She went to the Employment Tribunal having suffered some particularly unfavourable treatment from her employer, and the Employment Tribunal said that her symptoms were manifesting themselves in a minor and trivial way, so therefore not substantial, so she didn't satisfy the test for discrimination. The Employment Appeal Tribunal, however, absolutely disagreed and said, you're not thinking the law through properly, you're not applying the test, you've taken a really trite view of it without exploring it properly, and has sent it back to another tribunal to consider the law properly. I suspect the next tribunal will find that she was a disabled person. In contrast to that, Ms. Linsky brought a claim against her employer, and I'm not going to go into the details of the claim because unfortunately we don't have enough time, but just to confirm here, that tribunal did find that she was a disabled person consequent to her menopause, and did award her some compensation, just shy of £65,000 because of the less favourable treatment she'd suffered as a result of her menopause. So what can we do? And again, you guys are all on top of things because you're attending courses like that. So you are right at the forefront, I would suspect, of people policy. Many businesses have already done many of the things on this list, but if you haven't, it would be sensible to start training your managers, introducing menopause policies, considering flexible working, reasonable adjustments for people who are going through menopause, consider signposting, wellbeing champions, etc., much in the same way as we all have for mental health issues.
Phil, can I just ask? Sorry, I know we're never pressed for time, but it was one of the very first question that we were asked about, and it kind of feeds into what you're talking there about flexible working policies and claims that might be either coming through at the moment or in the future. have you noticed as an employment law specialist that this issue of remote and hybrid working and lack of flexibility is leading to an increase in claims from employees?
Necessarily no, because the flexible working regulations and legislation they're relatively easy from a law perspective to get round. If you tick a free process boxes and have a genuine reason for saying no, then it's unlikely that someone's going to bring a successful claim. And also, and I don't mean to sound ruthless about this, they're not very valuable claims for individuals as well. The compensation under the flexible working regulations is essentially 2 to 4 weeks pay. So
right.
it's probably more time, hassle, and upset than it's worth. The question about hybrid working and changing how we work, that's not necessarily playing through to the employment tribunal yet, but we do get a lot of questions about, well, what about Mr. or Mrs. Smith who's refusing to come into work, wants to work permanently from home, etc., etc. So that may come through to the tribunals at some point, but I suspect it will come through as constructive dismissal claims, where people are being refused to work in one way or the other, and they claim it to be a breach of trust and confidence, resign and issue constructive dismissal claims.
Okay, but that you expect that might come down further down the line?
Yeah.
Yeah. Okay. Well, listen, really, really grateful for that, Phil. Hopefully everybody found it really useful. I am conscious that there are a few unanswered questions, but we are pushed for an 11 finish. There was a question about the slide deck. Yes, the slide deck will be sent out to all of you, and I understand a recording will also be sent. If you do have any projects, HR projects that you need Phil's assistance on, if you look at the slide deck, his contact info is on the QR code at the beginning of that. But thanks everybody for your attending, and thanks to Phil for a great presentation. Have a good day all.